Hello, landlords. It's Ernie Garcia, landlord attorney, and I'm here again to talk about landlording. Today, specifically, rent to own deals. Are they any good? Let's get started. So, from time to time, I get a client who comes to the office and says, well, I entered into an agreement with my tenant for them to purchase the property. Now, these agreements look in all sorts of ways, and depending on how they're written up, they give the landlord certain rights and the tenant certain rights. In fact, sometimes you can't even still refer to each other as landlord and tenant depending on how the agreement was drafted. So drafting is a key issue in one of these rent-to-own scenarios. Let's talk about what that might look like. So you may sign a lease with a tenant with an option to buy. Now that option might have been purchased by the tenant for a certain amount of money. And the landlord and the tenant may have entered into an agreement that says tenant gets a right of first refusal and the landlord will not market the house for sale so long as this option period exists. Again, generally speaking, it's generally something that is purchased on top of the lease. It's something extra that is purchased by the tenant, that right to buy the property and to keep the landlord from marketing the property to somebody else. The other is the option to make an offer to buy, which is really not much of an option at all. This one is almost not much of a promise between landlord and tenant. All it says is that you are allowed to make an offer to purchase property, and sometimes a purchase price is established between the parties, and if the tenant elects, they can at any time agree to purchase the property at that time, but the landlord is not in any way prohibited from marketing the property to anyone else, but that at any time the tenant can elect to purchase the property for a stated price in that option. The other is a contract for deed. Now these can be tricky. And with a contract for deed, the landlord has a lease with a tenant. And the language in that agreement goes something like this. You are renting the unit for X amount of dollars per month. However, if you stay without default for a certain number of months, you will have accumulated enough payments that you will have purchased the property. You're still a tenant, and at any time that you breach, this contract can be terminated and forfeit. And so any interest you may have had is gone upon your default. And so these contracts for deed are a way to keep a long-term tenant where that long-term tenant very far down the line has the option of accumulating all of what was originally designed as rent to equal the purchase price of a property. And the last option is just the straight sale, but it might be an owner finance sale where the seller is selling property and taking a monthly payment from the buyer. In that case, the deed has transferred and the title actually goes to the buyer who, the seller is still collecting money from in what kind of looks like a landlord-tenant situation, but is not. And that comes to my first point. Does your paperwork between you and your tenant clearly delineate what your roles currently are? Remember that you cannot evict, even for non-payment, even for extended non-payment, you cannot evict an owner. So have you crossed that threshold? Have you made this tenant a buyer/owner of the property? In fact, if your documentation refers to this person as an owner, you probably have an agreement with them that you cannot enforce in the justice court. Well, what does the justice court have to say about this when you're raising an eviction? Well, even when there's a matter of non-payment, if you are attempting to evict someone who either has a record title or who has an ownership interest by virtue of your agreement, the justice court loses jurisdiction and they're unable to grant an eviction in a case like this. Has your written agreement identified you as a seller, or you were formerly a landlord, and your tenant as an owner or a buyer? If that's the case, you may run into trouble even after non-payment if you're trying to move forward with an eviction. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Second, is there a deed of trust in place? If you have a deed of trust, you may have transferred title over to a buyer, right? And so you are no longer the owner. Your buyer, who continues to pay you on a monthly basis, now owns the property. But if they signed a deed of trust, you may have an outlet for a non-judicial foreclosure. Perhaps you've engaged in a rent-to-own deal of some sort, or a straight-up purchase with owner financing, but your buyer, the person now occupying the home, has defaulted. And so now you want to recover either the defaulted amount or the property itself. You can do this, but you have to follow whatever the rules of your deed of trust say. If you're unclear, or if your deed of trust documentation is unclear, you may not actually have the power to conduct a non-judicial foreclosure. Well, what does that mean? Well, you may have to go to the court for a declaratory judgment to declare this contract breached and give you the right to recover title. That's a problem. And certainly if you have a deed of trust in place, you're going to have an issue presenting your case to the eviction court. You probably do not have a case that is suitable for eviction in this scenario. If you have transferred title, then a foreclosure is essential. You cannot skip that important step. If you have given an ownership interest to another party, and again, even if they are months or even years behind on payment, if their ownership interest is in place, either because you've actually signed title over to them or because the document that you have written with them states that they are owners, then you first have to foreclose. This requires proper notice and requires a proper procedure. If you can do a non-judicial foreclosure, that's the fastest way to recover title from a non-paying buyer. However, if you're not set up for a non-judicial foreclosure, you're going to have to file the proper lawsuit in the district court in order to recover title. Then you'll have the right to recover possession in a post-foreclosure eviction. Finally, if you are thinking about this kind of transaction, a rent-to-own or an owner finance transaction, you really should talk to a legal professional, because the designations that you have in the paperwork are going potentially to cause you problems. If there is an event of non-payment, what does state law say are your rights in terms of recovering title to the property again? What kind of time frame do you need to give a buyer who is in default? What kind of notification do you need to give them before you proceed with a foreclosure in the first place? If you don't know these things, you really need to talk to somebody who does. Essentially, if your paperwork is insufficient to protect your rights, then you could find yourself in a lot of trouble when default occurs. Finally, if you have given more rights over than you are aware, it's possible that you have violated certain provisions of the Texas Property Code. That may entitle a purchaser who is purchasing, for example, on a deed of trust, to all sorts of remedies that you may have had no idea exist. Again, if you've completed one of these transactions, if you're considering one of these transactions, before things go wrong, seek out legal counsel. Whenever you're entering into a legal arrangement with another party, whether that's to keep them as a long-term tenant or to make them a buyer, a purchaser of real property, you want to make sure that the paper that you sign gets the deal right and protects you in the event of some future default. It's very different when you sell a piece of property to someone and you step away. You take the full purchase price and now this is their issue. Maybe they're paying a mortgage to a bank or to some other party, but once you walk away, whatever happens with that house or any of the payments no longer involve you. But if you are still connected to either the purchase or a long-term lease, you want to make sure that the paperwork that you sign is completely intact so that your rights are always protected. Until next time, landlords, there's a video here that YouTube seems to think that you will enjoy, but I wish you nothing but happy leasing.